This is Professor Blackman.
Hi, everybody.
He's from Texas. And our co-panelist is going to be Professor Sobel. You all know her. She's amazing. I've never had her, sadly, but I've heard she's great. First off, I just want to say thank you to both of them. They both have families, and they've taken time out of their day away from their families to be here. So let's just give them a round of applause for coming out. And let's talk about some guns.
So, if we get to guns, who here knows what the Federal Society is? You know what FedSoc is? Okay, a couple people. So I'll just give a brief introduction to the Federal Society. Maybe you've never heard of it. Probably my first time at this law school, so I'm very happy to be here. I've been to Chapman once before, but not been here. The Federal Society is a national organization of conservative and libertarian lawyers who are committed to talking about the legal order. And one of the things that they do is they send professors like me to go to law schools across the country to speak on various topics. And I speak at probably 30 to 40 law schools a year. I'm always happy to visit new ones I've not been to. Especially, actually, my family in sunny South California today will be going to Palm Springs this weekend, so I'm ready to roll. The topic today is actually a fun one, and it's one I've had a lot of involvement with. It's the First Amendment, the Second Amendment, and 3D printed guns. Now, again, California, I have no guns with me. Don't worry, I have no props. I just have slides. Don't worry, don't have to arrest me. I'm good. But this is a case that I not only have some sort of academic exposure with, but I think actually practical experience. I've been litigating this issue for going on 8 or 9 years, so I'll talk a little bit about that as well. So first off, has anyone here ever used a 3D printer? Professor? What did you make?
Some things for my kids' school that they were printing out for a project.
Okay. Oh, what did they do? What grade did they do this in?
In elementary school, the library actually has a 3D printer in it.
Okay. Does everyone know what 3D printing is? Okay. 3D printing is a technology that's not super new, but it's relatively new. And what it lets you do is design an object on a screen and then convert that object on a screen to something in real life that is in 3 dimensions. So for example, you can design a car, you can design a house, and a 3D printer will take your design and then make it real. Anyone ever experienced coding with some code ever? All right, so this is very, very simple coding. I will not confuse any of you. So let's say I want to tell a computer that I want to make a sphere, right? Or a cylinder. I have to give it numbers. For example, I'll tell it, I want a cylinder with a height of 20 and a radius of 5. My magic 3D laser pointer will make this much easier. So I tell it I want a cylinder with 1 radius and 1 height. It'll know what to actually create. All right. It doesn't work anymore. No mind. No matter. Okay. This is kind of what a 3D printer looks like. And it can make all manner of gadgets. Sunglasses, toys with different transparencies. This 3D printer is actually making a race car. You can use it to make parts of human anatomy. There's actually a model of the brain. Okay, how does a 3D printer actually work? Has everyone made a candle before, right? No? Okay. How do you make a candle? You take a wick, or you dip in the wax, you pull it out. You dip in the wax, right here, right? You keep dipping, dipping, dipping. Every time you dip in the wax, the base gets a little bit thicker on the edge. 3D printing works in a very similar fashion. But instead of dipping into wax, you're spraying a very, very thin layer of plastic, liquid plastic. So see the little nozzle over there. Here it's making a ball, and it puts 1 layer down, 1 layer down, 1 layer down. And each layer is of different size and shape, so you can actually make an object like a ball. This is it from another perspective. You can see it's actually squirting the sort of plastic onto a heated bed to keep it nice and hot, so the liquid doesn't sort of solidify. All right, we'll get the gist of it. All right, now I want to show you a demonstration of how a 3D printer works. This is one by MakerBot, which is a very big company. And it's making an object that you will recognize, or you should recognize, especially in this part of town. All right, it's a hint. All right, so the very first layer put down is with what we call honeycomb lattice. Honeycomb is in a hexagonal, that is a shape with 6 sides. And this is a very strong way of building a 3D printed object. So we have 1 layer, 2 layers, 3 layers, 4 layers. You see it keeps getting a little bit taller, taller, and taller, and each layer is a little bit different size and shape. Does anyone see what's being made yet? Not yet. All right, keep going. 5. You don't see it? No. 6. You don't see it? 7. You don't see it yet. Say it. Shout it out.
Washington,
Ballpark.
Madison,
It's a figure. I'll give you that much. And that's it. How about now? How about now? No? You're gonna hate yourself in about 30 seconds. How about now? Yoda. Right. Look. Okay, now you'll see it, right? We're in Southern California. This is the Star Wars Adventures, a couple miles away. Yes, Yoda. Okay, now you all see it from Star Wars. It's not the baby one; it's the grown-up one. And now you all see it, right? Okay. But I like this demonstration because it shows you how, by simply putting 1 layer of plastic on top of another layer, you can build a very elaborate structure. Okay, keep going. There it is. Okay. So look, I'm not artistic. I can't sculpt. If you give me a piece of clay, if you give me a piece of stone, I can't chisel it. If you give me a piece of wood, I can't carve it. I have very few artistic skills, but this I can do, right? And all of you can also. 3D printing is a way of taking someone who has no artistic talent and lets you design objects and make some pretty cool gadgets. But, you didn't invite me all the way to sunny California to talk about printing Yoda. That's not very interesting, right? You invited me to talk about guns. And in particular, creating a functional firearm with a 3D printer. Okay, so let's jump back about 12 years or so. Maybe you guys were in middle school or so, with the Liberator. The Liberator was actually a very famous gun from World War II. And this was a type of a gun that could be made with scrap you find around the house. It was actually designed to be dropped behind enemy lines for the resistance against the Germans. Basically, a weapon that our allies could use behind enemy lines to fight the Germans. So it was actually a very innovative weapon. It wasn't very good, wasn't very accurate, but didn't have to be. Because if someone's coming at you with a gun and you have a gun too, it sort of evens the fight, at least a little bit. So in 2012, there was a law student, much like yourself. His name was Cody Wilson. He was attending law school in Texas. And he made international fame by building something also called the Liberator. This. You might say, Josh, what the heck is that? That's the design, the schematics for the barrel of a gun. It's basically a cylinder, not much different. Cody also designed, anyone know what this is? This is California, probably not.
Lower front area.
You're not from here, are you?
Oh, I'm here from here.
Okay, good for you. I have to remember where I'm giving a talk before I assume what my audience knows. This is illegal in your state, but this is a lower receiver for an AR-15. This is basically the guts of what makes an AR work. It's sort of a weird aspect of gun law, but most of the gun is not actually regulated. What's actually regulated is this one part. If you want to buy this part in a store, you must go through federal background check, and California has its own restrictions on them, and I don't want to get started on that. It's very complicated. But Cody found a way of 3D printing the guts, the receiver of the gun. Okay. But what made Cody, again, globally famous is this. What on earth is this? What are we looking at, right? It's these squiggles, these little blue things. These are all the parts necessary to make a fully functional pistol. The blue thing in the corner, that's the handle, the thing that you hold. The sort of triangle-shaped slanty thing over there, that's the receiver, which actually holds the bullet. The little cylinder at the bottom, that's the barrel. The little squiggly, spirally things, those are basically the springs. When you pull back the hammer of the gun, when you pull back the action, it can go into place. Now you notice there's two pieces of metal there. Everything else is plastic. What's metal? The first is a nail, a common household nail. And the second, there's a bullet. Okay. Everything else is made out of plastic. Now, again, I assume nothing in California. How does a gun actually work? It's actually pretty simple. In the back of a bullet is some gunpowder called a charge. And then you have a nail. If you strike the back of the bullet with enough power, you create a spark. The spark ignites the gunpowder, and it sends the projectile flying forward, right? Basically, make it simple, like a firework, right? If you light the bottom of a firework, it goes off and makes a kaboom, right? It's the same idea, but instead of putting fire on the bullet, you strike the back, creates a spark. So what happens is when you pull the trigger of this gun or any gun, what you're doing is you're basically igniting the charge on the bullet, sending the projectile forward. So really all you need to be metal is the firing pin, which strikes the bullet, and the bullet itself. Understood? Someone get me? All right, good. This is what the Liberator looks like when it's fully assembled. Now, I'm going to tell you up front, this is not a good gun. It's not accurate. It's not safe. I would never actually hold one. Now, if you look carefully, you see in the bottom there's like this little yellow rope on the floor. Does anyone want to guess why there's a rope on the floor nearby this gun? Just like a wild guess. If you look towards, you might have an idea. What do you think that rope might be useful for?
Pulling the trigger away from it.
Yeah. Right? Plastic. What happens when plastic gets really hot? It melts, right? We've all seen this, right? And when plastic suddenly gets very cold, what happens to it? Cracks. What happens when you pull a trigger on a gun? It gets really hot real quick, and it gets really cold in like a few seconds. Steel is a very good way to make a gun because it's metal. Metal, when it gets hot, it expands, right? And when it gets cold, it contracts, and it's a very good property. But a gun does not. When it's made of plastic, it melts or blows up in your hand. So the reason why that rope is there was so they could do test firing and not lose fingers. Right? So what they would do is they would put the rope on the trigger and they would stand many feet away and they would pull up. They test it. Now I can tell you, a lot of these guns blew up before they got to a safe one. In fact, again, I would not personally hold one of these. These are not safe guns to hold. They're also not accurate. Again, California, I'll assume nothing. What makes a gun accurate is called rifling. What's rifling? If you ever look in the inside the barrel of a gun, which hopefully you never do from that side, right? There are these grooves on the gun. Think of like a spiral of a football, right? You ever see a quarterback throw a ball, makes a spiral? That's what makes it accurate. If you're just like toss a ball, you can't control it. What makes a bullet accurate is that spiral. You have these grooves on the gun, so when the bullet goes out, it sort of spins at a very high velocity. And that's what makes the bullet follow a straight trajectory, straight line. This has none of it. You can't put rifling in plastic, it'll break. So basically, when you fire a gun, you have no idea where it's going. It's just going to fly out, say if you just toss a football without any sort of aim. So again, gun not safe, not accurate. It's also very hard to make. This might take on average 40 hours of labor, right? The parts, in addition to taking time to printing, you have to basically treat them with chemicals. You have to basically put the barrel of the gun in the special bath of acetone or other chemicals to strengthen it so it can handle the resistance, right? So this is a a very hard gun to make. It's not accurate, and it doesn't actually do much for target practice or anything else, right? But still, Cody made international headlines. When he released this weapon in 2013, people freaked out, like, oh my God, We're going to have all these plastic guns everywhere. They're not detectable. It's going to change the world. It's going to be the worst thing in the world. We have to stop it. So you might ask yourself, is there a problem here, a legal problem? Besides whether you like it or not, is there a legal problem? So usually when I talk about 3D printed guns, this is the image that sort of comes to mind, right? You just press a button and the gun pops out of a printer, and it's not that easy. Okay. The second item you get asked about is, Josh, can't you already make a gun in a much easier fashion than having a 3D printer? And the answer is absolutely. I'm not encouraging anyone here, but do you know what a zip gun is? Does anybody know what the zip gun is? A zip gun is a gun you can make at home using household parts. I'm going to tell you this. I'm not encouraging you, but it's actually very easy to make a gun. Very simple. So this is one model you can find on the internet in 5 seconds. It is a garden hose and a soldering iron put together. That's a gun. Go to Walmart right over there. So I put some groceries before. You can buy these parts for about $5. Okay. It's very easy to make a fully functional. By the way, this is metal. It's not blow up in your hand if you try to use it. I'm sorry. I found these blueprints online. This was a flashlight keychain. You know what this is, right? You have these little keychain flashlight. You've seen these? So some genius hollowed out, emptied out the middle of the keychain, and made a fully functional gun. All you need to make a gun is a tube that can handle heat. That's really it. And you put a very small bullet. All right. Next, I'm going to show you a demonstration. Please, please, please do not try this at home. Please, this is very stupid. These gentlemen, you know they're serious because they have a flip phone. They are serious here, right? Do you know what a flip phone is? We've never actually seen one. Anyway, she's laughing. Good. These gentlemen are going to make a rifle out of a rubber tube and a metal pipe. Again, please don't try this at home. So why are they using a metal pipe? At the edge of this metal pipe is this little dimple that sticks out, right? All right, so what they're going to do, you know exactly what they're going to do. They're going to load this red shotgun shell cartridge into this rubber tube. And they're going to jam that metal pipe into the back of the tube to create a spark, which will send the projectile forward. Now, what's wrong with this picture? Come on, remember like when you're a kid, which of these is not right? What's wrong with this picture? They don't see it. Where are they firing this gun?
Inside.
Yeah, they're inside. But look what they're firing into. What are they aiming at? Cardboard box. And what's behind the cardboard box? Electrical wires. Do you all see this yellow cable hanging out the front? Let me show you another one. This will make the picture a little more clear. Everyone see that? Again, I swear, don't try this at home. These guys are idiots, right? Actually, that's mean. They're putting their lives in their line because they have electrical wires dangling out. They have a fan spinning. They're inside a garage. And if I count right, the box has 4 or 5 bullet holes already in it. So they've done this before. They did a test run before they put it on YouTube, right? And this is actually a video. You can find it. I'm not going to give you the link, but you can find this video online somewhere. So what are they going to do? They're going to jam it in. Ready? Ready for this? 3, 2, 1, boom. Again, I don't show you this video to give you a how-to. My point is, if you want to make a gun, it's actually not that hard. I know your government likes to tell you it is. It's not. This is probably far more lethal than the Liberator ever would be. It's actually a much higher round. It won't blow up in your hand. It can handle the combustion. Rubber is actually a decent material to use. And by the way, maybe you've never fired a gun before, but there's a lot of kickback. So this guy's got to be pretty strong to hold it with nothing but a rubber tube. I mean, there's a lot of strength there, so I will give him his props. He's always so proud. The smoke coming out, he's showing off to YouTube, right? Notice his face is not in the video. That's probably a good idea. But they're trying. It's all about the subscribers. If you like and subscribe, no, it's just please comment below. Right. So my question is what these people did illegal? And I'm going to put aside California for a minute because everything's illegal here. Right. But sorry. But in most others, if you ever watched the musical Hamilton, there's this one line where Alexander Hamilton was killed in New Jersey. It was in a duel in New Jersey. And this one line is, everything's legal in New Jersey, right? When they talk about dueling. So everything's illegal here. But under at least federal law, is there any problem with this? Is there any illegal dispute? So the Bureau of Alcohol, Tobacco, and Firearms Explosives, this agency, has long taken the position, and this has sort of changed, but not really in the recent administration. The position has been this: if you make a gun for yourself and you do not put it into commerce, the Commerce Clause, right? If you do not put your gun into commerce, you just keep it for yourself, you don't need to go through any background checks. You don't need to go through process. You just make it for yourself. If you sell it, you're in trouble. If you give it away, you're in trouble. So this idiot who made this gun out of his rubber tubing did not violate any federal law. So wait a minute, Josh. If you can make your own gun, why are we even talking about this 3D printed stuff? What's the rub? Well, what's been fascinating about the 3D printed litigation is that it's not been done by banning people from printing them. That's actually only more recent. The earliest attempts to regulate 3D printed guns came with the code. That there were efforts by the government to prohibit sharing the code used to print these arms. The code. And that's where I sort of come in. Way back in 2012, I started teaching. And I wrote an article. That's what we do. We write articles. No one ever reads them. And I wrote an article about 3D printed guns. And I said, look, there's some argument that the First Amendment and the Second Amendment protects the right to 3D printed guns. I didn't really think much of it. No one reads our stuff usually. It's true. But then out of the blue, I got an email from Cody Wilson. Cody was the guy in Texas who made the guns. He says, I want you to be my lawyer, and I want to sue the government. I'm like, who the hell are you? What? I was kind of surprised. And we talked for a bit, and I found out that he actually had, he had other counsel. He wasn't sort of just flying rogue, and they were strategizing to bring a lawsuit against the federal government. Why? Because the State Department had actually sent him a letter saying, you must take down your files. The State Department? What the heck does the State Department have to do with putting files on the internet? And so the government basically said, when you put a file on the internet, you are exporting arms. I said, oh, really? Okay, well, maybe we can sue. So the major argument we've always had from the beginning is premised on the First Amendment. And as I'm sure as you know, the most basic, maybe you don't know you have the common law yet, but the most basic facet of the First Amendment is we can't impose a prior restraint on speech. That is, if you engage in some speech that's problematic, you can be punished afterwards. If you engage in libel or defamation or so on, you can be punished afterwards, right? If you inflict emotional distress, you can be punished afterwards, IED. But generally, the government can't stop you from speaking in advance. And in many regards, that was what was going on here. The government said, you can't put these files online. You can't share this information. The first question is, Josh, come on. We're not talking about, political speech or, talking about poetry or art. You're putting out dangerous information. These files are harmful. They can kill people. So one response, you know what this is? Thank you, California. Yes, right. The Anarchist Cookbook is a very popular book here in the 60s and 70s, right? This is basically a terrorist handbook. I'm only slightly exaggerating, right? How to make bombs, poisons, how to do some very bad things. And believe me, there were efforts to ban this cookbook decades ago, right? And bookstores, now they said, no, we have a right to sell before Amazon. Actually, there were these things called bookstores, right? They sold books, and these bookstores were able to, put these books in their shelves. Right? And they might say, wait a minute, Josh, okay, fine, that's a book. You have code, right? And this is actually a point that not everyone always agrees on, but I think has some salience, is that information is speech. And that just because you use code to convey your information does not deprive it of First Amendment value. Indeed, the Supreme Court has said that the creation and dissemination of information are speech. The court has held that violent video game, It's a California case. Brown versus EMA. Violent video games are protected speech. There's a case this year where social media companies are saying that their algorithms are protected, that they have the right to, promote or demote information to get, whatever they wish. Code is speech. We live in a world governed by speech. We live in the Matrix, maybe. I don't even know. But this is not just about the First Amendment. It's also about the Second Amendment. The Second Amendment, in case you haven't read it, it says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And back in 2008, there was a case called District of Columbia versus Heller. This is Mr. Dick Heller. He lived in the district. He was actually a federal security officer. His job was to save the lives of federal judges. He had a gun for work. But when he went home, he could not have a gun because he wasn't trustworthy, I suppose. D.C. banned possession of a firearm. This case went to the U.S. Supreme Court, and the court held that the Second Amendment protects an individual right to bear arms that is not connected to militia service. Individual right to bear arms. 2 years later, the court decided McDonald v. City of Chicago. This is Otis McDonald. He was a Chicago resident, lived in a very rough neighborhood. He wanted a gun to defend himself. Chicago said, no, you can't have a gun. He went to the Supreme Court also, and he prevailed. And the court held that, yes, the Second Amendment guarantees a right against both the federal government and the states. I met both Heller and McDonald. They're pretty cool guys. So it's good to see them here. I like this cartoon. Chicago Handgun Lost. And here's a picture of Heller and McDonald together. Actually, Otis McDonald died about 2 or 3 years ago. He was a really good guy. You ever think about who the people are? Roe v. Wade. Who was Roe? Her name was Norma McCorvey. Right? She was a single mom. She had given a couple kids for adoption. And it's kind of a sad story. She'd want to get an abortion, but the lawyer said, you can't get one because if you do, we'll lose our case because you'll be mooted out. So she actually carried the child to term and actually delivered it and gave it for adoption. The people behind these cases are fascinating. You always sort of forget about that in Conlon. I always like to give a little bit of background where I can. So that's McDonald and Heller. So I've talked so far about the First Amendment. I've talked about the Second Amendment. But let's dig a little bit deeper. And I think you can sort of reason that not only is there a right to bear arms, but also a right to acquire arms. And there's a simple reason for this. I mean, imagine the government said, okay, if you have a gun, you can keep it, but you can't buy any new guns. No more acquisition of firearms. That sounded very good, right? Because if you were, a child, you just moved, you don't have a gun, how are you going to get one? What if you have a certain need for it? So I think you can say the right to bear arms also includes the right to acquire arms. Some courts have held this, but the Supreme Court has not addressed the issue. Heller was a little bit kooky, and this is one of the pictures he put on his social media. So I'll just leave that one there. This other right that I'm actually feel a little more confident about, which is a right to make arms. A right to make arms. And long before there were gun stores, we have a tradition in this country of making your own arms. And this tradition goes back to the American Revolution. People make their own muskets, their own musket balls, and other types of arms. But we have here not just the First Amendment and not just the Second Amendment. We have something also that might be called a hybrid right, which maybe you came across in common law. And I'll just give you a very easy example, right? Let's say, I don't know, California makes it a crime to say Merry Christmas, an actual war on Christmas, right? Would that violate your free speech rights? Would that violate your free exercise rights? Or violate both? Probably both, right? Because you have a right to sort of talk about your religion, Merry Christmas, also a right to speak. This is what's called a hybrid right, where one right reinforces another. They sort of work together in tandem. And here what we have is the government saying you can't speak about guns. Now, admittedly, this hybrid rights concept, the courts haven't really developed much on. In fact, I'm not sure if it's even good law anymore, but there's some cases about it, so I'd like to raise it. All right, so the leading law on the books discussing 3D guns was actually passed before most people were born in the late 1980s. It's called the Undetectable Firearms Act of 1988. None of you were born then, right? No, it's okay. This law was passed in the 80s, and it makes it a crime to have a gun that has no metal in it. You have to have a certain quantity of metal in it. Why? Enough to set off a metal detector, a magnetometer, if you will. Okay? Now, you said, wait a minute, Josh, what that Liberator, right? Remember you showed me that plastic gun? Does that have any metal in it? Well, kind of. So according to the instructions of the Liberator, you must put a block of metal in the handle. The block serves no actual purpose, but it does comply with the law. Now, why did they have this law in the 1980s when 3D guns are only, 15 years old? The answer is the Glock. The Glock became a very popular handgun in the 1980s. Anyone ever heard of the Glock handgun? If you heard any lyrics of songs, you've heard this. You've heard the name of this gun. It's just rappers like using this word. But the person who actually made the Glock the most famous was Bruce Willis in the Die Hard movie. Ever see Die Hard? Best Christmas movie ever, right? Right. Okay. Right. Okay. I can see people nodding. This actually might have been Glock, Die Hard 2, which was this one with the airplane, so it's not as good as number 1. But anyway, Bruce Willis, the John McClane character, said, "Luggage. That punk pulled the Glock 7 on me. You know what that is? It's a porcelain gun made in Germany. It doesn't show up in airport X-ray machines here, and it costs more than what you make in a month." Now, that sounds really scary, right? But every single word of that is false, right? There is no Glock 7. The model doesn't exist, okay? The gun is not made of porcelain. It's made of metals and plastic parts. It's made in Austria, not Germany. It will show up in an airport X-ray machine, and they're very affordable, right? But basically, Bruce Willis said, these are dangerous guns. People got scared. They had to ban them. But basically, the fear of the Glock really led to some of these legislations. Again, so that's 1988. So if you have a gun that's made 100% out of plastic, it's a violation of federal law. You cannot possess it. That's the law. It's been in the books now for almost 40 years. Okay. What about bans on 3D guns? After Cody sort of came on the scene in 2012, 2013, there were efforts in Congress to try to ban these guns. Here was Senator Schumer showing a picture of the Liberator. He wanted to ban these guns. That legislation went nowhere. So there's no actual federal legislation that speaks directly to bans on 3D guns. That statute doesn't exist. States have them. I'll talk about the states in a minute. Your state has something on it as well. One of the other proposals I saw that didn't gain much traction was a ban on materials. Some people said that it's so dangerous to have 3D printed guns that we should ban 3D printing altogether. No more 3D printing plastic. But guess what? You can 3D print metal. Yes, this is actually possible. There's a lab in Austin called Solid Concepts. This is a model I held in my hand. It's a fully functional 1911 handgun made out of steel, 3D printed. So you can't really ban plastic. That won't get you far. So then what has been the primary method that's been used to regulate 3D guns? Well, again, it hasn't been a control on the gun itself. It's been a control on the sharing of the information. All right. So has anyone done something with export control law? Anyone ever hear of it? Okay. So back in the Cold War, we started developing something called ITAR, which stands for the International Traffic in Arms. And this statute makes a lot of sense, right? If you want to send Stinger missiles to Afghanistan, you should probably get the government's permission. I think we all agree on that one? Yes, right. If you want to send blueprints on a nuclear submarine to China, probably get the government's permissions for that one. I think we all agree on that one? Okay, good. Right? If you want to send, radioactive material, we all agree. If you're sending weapons to our adversaries and other nations, we should probably have the State Department say, yeah, good job, or no, don't send that abroad. But what happened in the 80s and the 90s was that the ITAR was sort of expanded to not only apply to arms, as the name suggests, but information, words on a page. And where this really hit the road was in the 1990s with regard to cryptography. You know what cryptography is, right? Cryptography are algorithms that secure information. Same way you have a password on your phone. If you don't have the right password, you can't access the phone. Your information is encrypted. And the government started saying, oh no, if our adversaries get this encryption technology, or NSA can't read their emails. I'm slightly exaggerating, but in other words, if the bad guys have cryptography, we can't snoop on them. So we can't have that happening. So the government said, we're going to ban the export of certain cryptographic algorithms, so our adversaries in other countries can't evade our snooping techniques. I'm exaggerating slightly. This is actually litigation here in California called the Bernstein litigation. It went on for like 7 or 8 years and sort of ended in just this kind of fizzled out. It didn't actually go anywhere. But several courts did hold here in California, federal district court, that the First Amendment protects a right to share information. This was back in the 90s when no one really cared about this topic. But among hackers and computer nerds, this was actually very important. Okay, now fast forward again till 2013. Okay, 2013 is when Cody Wilson made international headlines. They mentioned he put these files online. The State Department wrote him a letter and they said, "Dear Mr. Wilson, we are the government. You've put these files on the internet. You should not have done this. Please take down these files immediately." The government said by putting these files online, you are engaging in the export of arms. Again, he didn't put anything in an envelope to mail. He didn't send guns to Russia or China or anywhere else. He put these files on the internet. But one of the facets of being on the internet is that anyone can access these files, right? Later, we would actually experiment with limiting access. Remove these files immediately. And he did. Cody did take down the files immediately. And that's where I came in. After he took down the files, he called me and we spent some time. We prepared a lawsuit against the government. Okay, that was 2014. We now are in the year of 2023, if my memory serves. Litigation ain't over yet, right? One thing you always see on TV, cases get resolved in 5 minutes or in a single hour episode. Not in reality. So Cody's been litigating against the federal government, New Jersey, California, and a host of other states for years. The federal litigation is more or less trickled to a halt, but it's not really over. It's still ongoing. The more recent litigation involves states. And states have now enacted laws that make it a crime to 3D print a gun. And they make it a crime to also share the information needed to make that gun. Eventually, we'll get a ruling on the merits from an appellate court. We've actually still been stuck in district court for years. This is some litigation I've actually been very fond of. The part that my interest is the most is really in the First Amendment analysis. Because in really any other context, a state banning sharing information on the internet would raise hackles, right? And I use this analogy, it's gross, but I'll use it. Imagine if Alabama passed a law saying that you can't share blueprints for sex toys, right? If you want to 3D print a sex toy, that's illegal to share in Alabama, right? I have no doubt that various groups say violation of the Constitution and so on. But again, this is not sex toys, this is guns. And guns, for a host of reasons, engendering much greater reaction than perhaps sex toys does. But the First Amendment issue is still there. And we still have a solid ruling for courts saying this is actually speech. A lot of courts have said that these are files that are not expressive, that they are not entitled to First Amendment protections. And we'll keep on litigating until we get there. All right, I've spoken enough. Thank you so much. Happy to hear from my dear colleague and also questions for you all. Thank you so much.
So one of the things that I love about the practice of law, or about learning about the law, is you can find out about things that you had no idea about before you walked into a room. And so that's, I think, one of the joys sort of about law school or practice of law. I want to thank the Federalist Society for organizing this for today. And part of the reason why I was interested in speaking about this topic is also actually related to the Federalist Society. It's about in 2009, a student in my common law class, who is the head of the Federalist Society, said to me, "Are you interested in mooting the attorney who's going to be before the Supreme Court next week for McDonald versus Chicago?"
Oh, wow.
And so I went to UCLA and I helped moot the attorney, and had a couple of very impressive scholars and experts on it. Adam Winkler was doing it, and Eugene Volokh was doing it, and a variety of people. And the Second Amendment really wasn't sort of my area of interest at the time. And I was like, sure, I'll do this. And then I had to learn all about the Second Amendment. And so because of this invitation, that's how I started my interest in it. And part of what was really interesting to me as we were going about, discussing the case and preparing for it, was that there really weren't a lot of gun cases out there. that the Supreme Court hadn't really decided a lot. And so when I teach constitutional law or I teach criminal procedure, there are a gazillion search and seizure cases, but there just really wasn't a big body of law. And one of the things that I write about and that I'm always very interested in is what's the right standard of review? And part of this was because I was a practitioner before I taught law school. And so as a practitioner, you always kind of want to know, what's the test? How am I going to know as an attorney what's required of me in order to make the case for my client? And so we finish mooting this guy, and so just
Was it Alan Gura, by the way?
Yeah.
He's my co-counsel in this case.
Oh, really? And so we finish mooting him, and we're talking afterwards. And I said, look, this is an easy case for the Supreme Court. So just so you know, when they have the decision in Heller, that's really limited just to the District of Columbia. And so when they say you have a First Amendment right, it's really sort of limited, and depending on whose version of it you look at. And it's not just a First Amendment right to anything. It was sort of limited to sort of a First Amendment right, not First Amendment, Second Amendment right to possess a firearm in your home for the purpose of self-defense. But it didn't apply to the states. And so literally the next day after Heller comes out, a bunch of cases start getting filed. They now want to test whether that case, Heller, is going to apply to the states or not. And so McDonald versus Chicago is the case that then rises up to the Supreme Court to test that concept. And so as we're getting ready, after the moot, I say, look, this is not a hard case. We already know what the court said in Heller. They've already said that this right exists. The real issue is going to be, what's the standard of review? How are they going to figure out whether a gun regulation is going to be valid or not? And in Heller, they don't really give any kind of clue about it. And so McDonald comes up again, and in the decision, in the dissent, Justice Stevens says, by not giving a standard of review, you're creating what he calls a tsunami of legal uncertainty, that courts just aren't going to know what to do. And so actually, because I have brought you joke around this, oddly, one of my more popular law review articles, people have cited to it. So it's called the tsunami of legal uncertainty. What's a court to do post-McDonald? So I wrote about this. And it's sort of this framework that I now want to discuss through some of the issues that Professor Blackman raised. And so I look at it from sort of an analytical standpoint. Professor Blackman has raised some very interesting issues related to, is there this First Amendment right to post this information on the internet? And there's a whole different standard, or many standards of review, related to what type of speech is being used. And so what interests me about this case is, if it eventually does get heard, how do we make these determinations about whether something's actually going to be found to be constitutional or not? And so the court, never told us until we got a case in the last year or so. It was a New York case, and it's called Bruin. And in that case, the court talks a lot about what was the history of gun use at the time of the founders. And they say that's important because we have to understand that when the Second Amendment was created, what did they mean by it? What did they intend by it? Other people say, well, if we're applying it to the states and it comes through the 14th Amendment, through incorporation, maybe we should be thinking about what people thought at the time that the 14th Amendment was passed. But the problem with that is that 3D printers weren't around at either of those times, nor, a lot of the arms that we use today. And so the question in part becomes, how do we apply whatever those concepts were to these modern technologies? And when we think about it in sort of this test, it concerns me a little bit, because we talk a lot about history and tradition, and I know some of you have had me for common law, others of you are somebody else. history and tradition comes up a lot. And so when we try to figure out, for example, what's a fundamental right? One of the first questions we say, well, is it in the Constitution? Well, the right to bear arms, and there's disputes about what that means. That's in the Constitution. That's a textual hook. And we'll say, okay, do we have case law on this? Well, as I started out, there's actually not a ton of case law on this. And so the next question sometimes becomes, well, is there a history and tradition of this case? So this concept of using history and tradition in a variety of ways, that's not a new concept to constitutional analysis. But what's different here is it becomes the end all and be all of Second Amendment analysis. They just say, if there's a history, that's okay. If there's no history, then, it's not. And so that is highly unusual. That history and tradition, for example, in the fundamental rights context, is only to determine whether the right is fundamental or not. It doesn't ultimately answer the question whether the government's infringement of a person's rights is actually valid or not. And what I think is going to be interesting to see, just last week, the court heard a new case that was about a person who possessed a gun, but also had been prosecuted for domestic abuse. And in a number of states, it is prohibited for people who have been found guilty of domestic violence to possess arms. And so this gentleman, no one's sort of arguing the facts in his case, is arguing that he did exactly that, but he has a Second Amendment right to possess guns regardless. And so part of the conversation before the Supreme Court was, well, what's the historical background? Was there a right to bear arms by domestic abusers at the time of the founding? Well, the answer to that is not really. We don't know. There was no laws that necessarily prohibited it, but that's because there's no such thing as domestic abuse or domestic violence, because women at the time were seen in some states literally as chattel or property. Other times, men were seen to have a variety of rights that came with the marital relationship that the government considered that they could sort of, they sort of ran the domain of the marital relationship, and that nothing would happen if you were accused of abusing your wife. And so to just look at things through a historical lens doesn't always apply to our modern world. Was there necessarily a history or tradition related to spousal abuse and guns? No. But were there other prohibitions at the time? And do we have to be tied to only what happened at the time of the founders? And so I'm just going to, I brought this with me because it actually has some quotes from Heller and McDonald in here. And, this was what Justice, here, I think. Here we go. So this is from Heller, or actually this is from McDonald citing to Heller. It says the Heller decision did not cast doubt on such long-standing regulatory measures as prohibitions on the possession of arms by felons and the mentally ill, laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. We repeat these assurances here. Despite municipal respondents' doomsday proclamations, incorporation does not imperil every law regulating firearms. And, this was not a, sort of the liberal wing that was saying this. This is the, sort of more conservative justices that were signing on to that. And so what that suggests is, at that point, they're already making a statement that it is constitutional in certain circumstances to limit rights under a whole host of circumstances. And they also say that's not a finite list. So if that's true, a lot of those things were not illegal at the time of the founding or prohibited in terms of, gun use. So does that now throw out that Supreme Court precedent where they said, hey, it's okay to limit the Second Amendment right in these types of instances. We've done it before, perfectly fine. But under this new analysis that the court is saying that we only look at the history and tradition, in theory, some of those things that were listed before would no longer be protected. And some of the justices during the arguments last week actually raised some concern about this argument that only historical things will be covered because of sort of the dangerousness that's been proved to people who are victims of domestic violence and abuse. And so when I think about these cases, I always sort of go back to, all right, well, what's the standard of review? So it is possible that they can limit potentially that decision Bruin from last year and how it applies to cases, or they can stick just to it. And so the court has said in a variety of contexts, in the First Amendment context, in the Fourth Amendment context, we don't limit the application of the Constitution to only those things that existed at the time of the founding. So we can apply, for example, the Fourth Amendment to new technologies, to drones, and to, heat sensing, sensors and things like that. So the question then becomes is, what kind of standard? How do we think about 3D guns? There obviously weren't any at the time of the founding. Does that mean there's no historical right to protect them? Or do we apply sort of the rules at the time to this same particular type of, to a different type of gun that they could have never imagined in the first place? Or do we go beyond history and tradition and actually let governments regulate with the standard of review that we see for other things? So I know some of you are first years, but some of you are not. And so you've had the opportunity to hear about standards of review and what level do we do, strict scrutiny, rational basis, and all these other things. And so typically, when we have a fundamental right that's at issue, often you'll see strict scrutiny, the highest standard of review, the hardest test that the government has to meet. So when we talk about standards of review, I'm not talking about giving the government a pass. But what I'm talking about is giving the government an opportunity to make their case. If we stop at history, the government doesn't really get that chance. It becomes a duel of historians. I'm going to just, I have a couple of things here from recent cases. Here's one judge, the Fifth Circuit judge, who says, he's talking to the lawyers, you each gave us, I think, 4 law review articles, not from historians, and we have 20 minutes to ask you questions. And the lower court judge didn't have a chance to ask a single question. He's talking about the history. Who gets to decide what the history is? Judges aren't necessarily historians. This is an article that talks about how there's now a need for experts on arms from the colonial period. And so they talk about now, we're exploring weapons bans in early saloons, novelty, air rifles, concealed carry restrictions on Bowie knives, 18th century daggers, string operated trap guns, and a whole bunch of other things. And so we're looking at things like that. And we've got a whole bunch of cases that they talk about. We've had people who could make at-home guns before, and there's a case about ghost guns in West Virginia. But they're saying, but how do we figure out what the history of this is? And so there's a Mississippi case where they say this court is not a trained historian. And we are not experts in what white, wealthy, and male property owners thought about firearms regulation in 1791. This is from Judge Reeves. And he wondered if the court should hire a neutral history consultant to help tell them what was expected at the time of the founders. Both sides objected. No one wanted the neutral person. Another judge in California actually wanted a compendium of all laws written during a certain time period in order to decide what the history of regulation was. And it was a 56-page list that was submitted to the U.S. District Court that included everything from dueling pistols and muskets to trick cane guns. And so it goes on, and it talks about this. And part of my concern about some of this is how do we figure out what's history and whose history is it? And I just wanted to read another thing that actually it's from Bruin, and this is from Justice Breyer's dissent. And he says, how we look at these issues is really important. And he talks about the Heller case and how they talked about how there was a right of having using arms for self-preservation and defense at the time of the founding. And Breyer says, but 2 years later, a whole bunch of 21 English and early American historians told us that the Heller court had gotten the history wrong. And then he says, linguistics experts also now tell us that the majority was wrong, to reject an argument that the founders' use of bare arms overwhelmingly referred to military service. And they then went back and they did this huge search of founding era texts from 1760 to 1799. And there were 40,000 texts that talked about it. But none of this was really researched and studied until after the fact. So even though it might appear to be history, we don't necessarily have all of history that's available to us at the time that these courts are making decisions. And so while I agree that there are constitutional issues that Professor Blackman has raised, I think they're valid and they should be discussed. The question then becomes, what do we do about it? What kind of test are we going to apply to this case if it ever gets litigated and we bring it up? And how do we figure out whether that particular regulation is valid or not? Because it's important to remember that just because someone has an individual right to do something, every right that we have, the court has always said is not unlimited. And so how do we figure out those limitations and what does that mean for this litigation? And so I don't really have an answer for that, but I think that one thing that I would say that history alone is not going to solve these problems and that we have to look deeper into them, including whatever the government's interests are going to be and how tailored their solution is to that issue. And so with that, I would love to hear if you've got thoughts about that.
I do. You saw my lovely family over here.
Yes, welcome.
Yeah, they're my roadies. So thank you so much. It's very often I do these talks and, Professor kind of just says, hi, any questions? So I appreciate Professor Sobel had some thoughts upon this. Right. The question of constitutional scrutiny is actually very significant. Well, what is scrutiny, right? So the way I explain it, think of a suit, right? You can have a suit that fits you really well, tailored perfectly, right?
Skinny jeans.
Skinny jeans, good analogy, right? I think it fits you perfectly. Or you have a pair of baggy gym pants, or a pair of, go to Walmart, buy a suit at Walmart so it hangs off you, right? Scrutiny is kind of like that. Something is strict scrutiny. It's got to be narrowly tailored. It's got to fit perfectly. What are you trying to do, and what are you doing to get there? That's a very close relationship. The suit's got to just be perfectly tight. Rational basis standard is good enough. You feel like getting dressed, wear some cargo pants, right? Wear some gym shorts, you'll look just fine. It's about deference, right? We're not going to be very strict upon that. So in the Second Amendment context, and I think Professor Sobel did a very good job laying out the landscape, the court never actually picked a standard review. And I think that's a product of the fact that there were not 5 votes to pick a standard of review. The court said for sure rational basis out, and that much was simple. I think that was easy enough. Any constitutional right is not going to be subject to a rational basis standard. That's just not going to fly. But they said, we will decide in a future case what that standard is. So we had Heller in 2008, McDonald for Chicago in 2010. So we had those 2 cases back to back. Neither case picked a standard of scrutiny. So what resulted was that all the lower courts were sort of left adrift. They didn't know what to do. And then over the months and then years in the wake of Heller, the court settled on what they called heightened review, which sounds a little bit like intermediate scrutiny, But the truth is the government almost always won. I mean, I can count on two hands the number of times the courts used Heller to declare federal and state laws unconstitutional. And if any did, the Ninth Circuit on Bach reversed it. I think there's actually a rule of the Ninth Circuit court, any decision if they're the Second Amendment gets en banc immediately. Hey guys, it's automatic. So the bottom line is almost every single gun control law survived whatever Heller said. And maybe that's the right answer. But over time, Justices Thomas and later Scalia began to dissent, saying, okay, we have all these cases in the lower courts, let's take another case. But the court didn't grant review in any of these cases. Do you guys have to go to another class coming up? I can wrap up soon. And as people are shuffling. That's fine, I'll wrap up in a minute. So over time, the court denied review in every case. For nearly a decade, the court would not address the level of scrutiny. And finally, 2023, we get the Bruin decision. There's a case that Mr. Sobel mentioned. There's a case from New York. Did the court say intermediate scrutiny? No, they didn't. Did the court say strict scrutiny? No, they didn't. Instead, they said no scrutiny. We don't care about Bruno. No, we don't care about scrutiny. It's just the kids are here, right? In the home of Disney. We don't care about scrutiny. And Justice Thomas said, when we have this fundamental right, we're not going to just balance means and ends. Instead, we're going to look to this text, history, and tradition test. So think back to your LSAT. I know you buried that deep in your mind. Yeah, not Elsa, LSAT, right? That's where my kids are, right? Think back to the LSAT and give analogies, right? This is to this, and this is to that. Yeah, you have to analogize. I'm giving PTSD from the LSAT. And what Justice Thomas said, if you want to have some sort of arms regulation today, you must identify an analogy, some analogical similar regulation that existed at the time of the framing. So, for example, in New York, what did New York try to do? They tried to ban the carry of guns inside the home. They said, unless you have a really good reason, you can't have a gun, right? Justice Thomas said there's not really a good analogy of any gun law for the framing that did that, frankly, because there weren't many gun laws at the time. Now, I will share some Professor Sobel's caution, because I don't think the court actually believed what it said in Bruin. I think they sort of said it. That was an easy enough case. I mean, took the right to bear arms. Bear means carry. That's not a hard case. But this analogical reasoning case is tricky because of the other decisions you mentioned. Rahimi. Mr. Rahimi is a bad dude. He's a bad guy, right? He beat up his girlfriend. He shot at people. Didn't hit them. He just sort of shot near them, and the bullets did strike. And he did this all in the span of a couple weeks. He did this period of rage. Now, he was never tried for these crimes. He was never convicted. Instead, a court entered what's called a domestic violence restraining order, DVRO, domestic violence restraining order, which said you cannot go near this person. You can't have a gun. All right. He had a gun anyway when the police raided his home, and he was charged with violating Section 922G of the U.S. Code, which makes it a crime to have a gun while you're in possession of violence, DVRO. I'll tell you about another case, Mr. Range. Mr. Range did something bad also. He lied on an application for food stamps. He was applying for food stamps, welfare. He lied. Welfare fraud is not new. It's been around for a very long time. He was also possessing a firearm. And guess what? If you are engaging in welfare fraud with a conviction, you can't have a gun. So the court has this one case, the Rahimi case, involving this guy beat up his girlfriend and shot people. And you have this other case involving Range, where a guy lied on a food stamp application. So my humble prediction, I'll sort of end it here, is the court says, well, with a non-violent felon, this is not really a tradition of disarming you. Martha Stewart, Martha Stewart, right? She can have a gun, right? She's 80 years old, looks fantastic, right? Martha Stewart can have a gun, crochet doilies for holster, whatever, right? Martha Stewart can keep her gun. But Mr. Rahimi, bad man. He's like Taka, right? He's bad. He cannot have a gun. And the court will sort of settle on this, not because of any sort of deep study of history, but because they don't want wife beaters having guns. Now, that's not a very good answer. I think it's probably where we'll wind up.
I was just saying, I'm going to add a little bit. I sort of agree with your additional summary on here. And that's actually what this article is about. It actually kind of goes through every single standard of review, and it says, did the court say that we could use this? And it says exactly what Professor Blackman says. There's no rational basis, no balancing test, no this, no that. So then I said, well, what's available to us? What can we use? And I actually come up with a recommendation, which now is sort of not as likely for even other reasons. But I actually say we should do an undue burden test. And the reason why is for some of the reasons that you say, that the government will always have a compelling governmental interest to regulate guns for safety and other reasons. The question really becomes, is there such a restriction of the Second Amendment right that the law becomes invalid? And that would allow certain laws to be struck down. And so I say in here, this would, I think, achieve some balance in the analysis. Because if you apply strict scrutiny, nothing survives, and the government will never be able to tailor it fine enough. And so what I say is, if we do sort of this undue burden test, then if you have certain cases, which is like this Ninth Circuit case called Nordyke.
And in Nordyke, what?
Yes, and so I say, if you have a case like that, it was about how you could, regulate guns at gun shows. That probably doesn't burden the right. That's probably not an undue burden. And I say, however, in Heller, it probably would be considered an undue burden on the right because the restrictions were so great that you almost made it impossible for that person to exercise their right. And so I actually thought that that was a way to still protect Second Amendment rights while giving the government some flexibility to regulate. No one's taken up my
But they didn't
suggestion.
listen.
They don't listen.
They never listen. They never listen.
Anyway, so I just thought you'd be interested.
Well, thank
in
you for that very much. I'm
Yeah.
happy to take questions from the students. Any questions that you'll have? Marcel? Shovel? Yes, sir.
The new test.
You look like Lin-Manuel Miranda, by the way. Want me to tell you that?
Huh?
He does a little bit. He does. No one to tell you that? So I was talking about Hamilton before. Go on.
No, the new test sounds like it's a lot similar to Dobbs. Is that where the court got their ruling for Bruin was from Dobbs? Because no, Dobbs is very history focused.
I don't know that one necessarily came from another. I think it's some of the justices for a while have been having conversations about the role of history and tradition. And as I said, when we look at fundamental rights generally, that's often a question we ask. Is there a history and tradition of this particular thing? And so the question is, how much emphasis do we put on that? And how do you look at it? Because if, for example, you look at a case like, Lawrence versus Texas, you'll see, for example, they say, oh, in our prior case, they said there was no history and tradition of this, and that was, Bowers. But here, we believe that the history and tradition are different. Just like Breyer says, hey, we thought the history and tradition in Heller was one thing, but now when we've briefed all these other cases, we find all these historians that say it's something different. So, from my perspective, I think that history and tradition can play a valid role in the analysis, but I don't think that should be the end all and be all. I don't think that's where the analysis should stop. And so that's what I would add to it. So some people say, all we should care about is what the founders thought. And other people look at the Constitution as sort of a different jurisprudential philosophy and say we can apply some of the originalists. They can say, apply the concept at the time of the founders, but apply that to today's sort of facts and roles. And other people think that we don't have to limit our lens of the Constitution to the time of the founders or history and tradition, and we can look more broadly. And so there's become a shift in who's on court over the last number of years. And so people who have put a greater emphasis on history and tradition, now a trend that's happened over time. But the question is, does it stay depending on, what happens with the court?
Very good. What other questions you have? Miriam, any questions?
Why was that guy a bad guy?
Oh, because he hit his girlfriend. Very bad guy. His name was Zaki. Really bad guy.
So I understand the First Amendment argument about the spread of information to code firearms and how that potentially could be dangerous. And I understood your comparison to the publication and distribution of the Anarchist Cookbook. But don't you think that the times have changed where having information present to readily available to the masses such as how we have communications through internet, things like that, doesn't that present much more danger than the anarchist cookbook ever did?
So I'll take a step back and answer the question more broadly and maybe reference social media in general. Right? It's absolutely true that through the internet and social media, you can spread knowledge around the world instantly. And I would ask for just consistency. If we actually take the position that the internet's dangerous, then there's lots of information on the internet that can be dangerous, right? The government may decide to impose censorship. China, North Korea, other countries have done that. But the only context where this has actually been done is in the Second Amendment context with 3D printed guns. And there's lots of other types of files that are likewise dangerous. So if the Supreme Court wants to actually hold that information, sharing information is not protected by the First Amendment, okay, they can so hold. I think what I've tried to also demonstrate, though, that is the files we're talking about here are not the sort of things that actually are actually a threat. There are a lot more easier ways to get the gun than to have to 3D print it. And I think it mostly just sort of scares people because they think, oh, plastic gun's undetectable. There are a lot of other easier ways to make it. So I don't think if you want to talk about proportionality, that the sort of the ban on sharing information is in any way consistent with the actual threat these guns pose. Thank you for the question. Yeah. Oh, I thought you were going to go. All right. What other questions do you have? Anyone else who hasn't asked a question yet? All right, go for it.
What about the Glock switches? I know that's like the newest big thing, and that's a very big threat to law enforcement. Does that also, do you feel, is protected as well?
Right. So if you know what a Glock switch is a type of a handgun I referenced earlier, and a Glock switch is basically a little device that can help convert a gun from semi-automatic to full automatic. Okay.
Yeah.
So what does semi-automatic mean? Semi-automatic means you pull the trigger once and then one bullet comes out. Automatic means you pull the trigger once and it sprays, right? Just a machine gun if you ever see the movies. The Glock switch is not legal. In other words, the files used to do this are not legal. You might say, well, what if you just sort of ban files that can be used to make illegal things? All the guns that we've actually advocated are those that are legal under federal law. They're not illegal under state law, as our good friend in California will tell us. And we actually created what we've called a blue wall. If you try to access our files from California, you'll not be able to access them. It's actually pretty rigorous. You have background check, things like that, with credit cards. So we're actually able to find out where you're at. It's not foolproof, but it's actually pretty decent. So in terms of the Glock switch, that is illegal. I don't know that I'm in favor of having states ban me and try to prevent the sharing of these files, because why? There's a million ways to share them on the dark web with torrents and the like. So I think these laws probably will sweep in far more speech than they actually will police. That might jump position. But the Glock switches have become very popular, and popular is the wrong word, but become very problematic in recent years. All right, maybe one more question. Yes, sir.
Does the originalist approach to Constitution, I guess that's a bit of what Sol said, like carry some danger of, I guess, keeping the country stagnant in a sense? Because as Sobel mentioned, we have been, like, for better or for worse, an ever evolving like country and society, that we've had had numerous amendments to the Constitution. We never kept ourselves like deadlocked in the first set that the founders made. At the time, it's like stagnant instead of trying to like innovate and adapt to the times and situations that are going to go on these upbringings.
Right. So again, it's a good question. I have no problem with innovation. It just depends who's doing the innovating, right? We've had amendments. 13th, 14th, 15th Amendment were pretty significant, and those are part of the Constitution. So it's not just first founding in 1787, it's the second founding in 1868, right? That's part of the Constitution as well. The originalist project, though, was aimed at the judges, and many decisions rendered in the 60s, 70s, and the 80s, and even the 90s and 2000s were based on the judge's sense of decency. I'd much rather be governed by, the people elected in Sacramento or in Austin than be governed by the 5 lawyers in the Supreme Court who can make this sort of decisions on their own. So I think in terms of why originalism is an important project, it's who decides, right? Who gets to make these tough decisions? Now, I understand that the comeback will be, well, the people of New York and Albany decided this was a very good gun law, right? And that they couldn't enact this because of what 6 lawyers in the court said. I think that's of course it's a fair argument in response. I agree, and maybe not everyone agrees, that the Second Amendment at least protects the right to bear arms, which means to carry. And in New York, the only way to have a carry license is basically popular. This is actually how the regime worked. If you showed what's called good cause, they would give you a carry license. How do you show good cause? Well, if you're friends with the sheriff, if you're a celebrity, you get one. All the VIPs in New York got them, but the poor schlubs in upstate New York and rents their collection, they didn't get one. So I think the New York regime was unconstitutional 2 ways to Sunday. Right? You can't have a constitutional right subject to someone's pure discretion. So you don't even like the Second Amendment, this is a bad law. In terms of the Rahimi case with the bad guy who beat up his girlfriend, I think there's a 0% chance this guy wins the case. But if you're Martha Stewart, you're a nonviolent offender. There are not many good reasons to disarm you for life. People need these weapons for self-defense and otherwise, and that's where I fall. But originalism is primarily designed as a constraint, so that it's not the judge's own sense of well-being that decides the law, but there's perhaps some sort of meaning that is rooted in where our Constitution came from. Thanks for the question.
And I'll just add to that, well, there's an argument for that. Some people would say that the Constitution was never meant to be static, that we have the 9th Amendment for a reason, and that there are other rights that are not included in the text, and that they didn't make the Constitution as a laundry list, nor intend it to remain exactly as it has. Now, I agree that if people feel strongly about something, there is the avenue to go and to amend the Constitution. But I also think that it's unrealistic. There's just no way the founders could have ever imagined what life would be like today, nor that Black people would be free, women would be, voting or holding other amendment and how it's been applied. But there are even some justices in the past who said, for example, women are not protected under the Equal Protection Clause, was only meant for race-based discrimination. And it's wrong to discriminate against women, but that should be handled by a legislature, not by the Constitution. Justice Rehnquist used to talk about that. And so while it does say you have the right to bear arms, if you want to look at it from that perspective, then similarly, we should be allowing states, to be making laws about restrictions. No right is unlimited. So that brings it back to then, what's the test?
Very good. Thank you. I'll let you have the last word. Thank you all so much.
All right. Thank you for coming.
Thank you. That's fun.
So I didn't know that you don't get a response.
It varies.